This video is about the United Nations Convention on Contracts for the International Sale of Goods, also known as the CISG. We will cover the more important issues regarding the subject, including the content of the treaty, the participants, the importance of participation and the type of goods, some examples, the Incoterms 2010 and their relation to the treaty, and new European laws regarding international sales of goods. The CISG treaty is divided into 4 parts, which each are divided into sections. The first part is the sphere of application and general provisions. In this part, some general information regarding the application of the contract is given. The parties are named and the type of goods are clarified. The second part is about the formation of the contract. The regulations regarding the contract and its content are explained. Some rules are included regarding a revoked offer or the change of an offer. The third and largest part of the treaty is about the sale of goods. This part includes 4 important sections: obligations of the seller, obligations of the buyer, passing of risks, provision, comment to the obligations of the seller and the buyer. This part goes deeper into the subject of the deliverable goods, documents and payment. The risks, including risk regarding breach of contract, is covered and the obligations of each party is discussed. Last but not least, the final provisions include when the convention comes into force.
The CISG is considered one of the most successful international treaties ever made, and it is ratified by over 78 countries. Nearly every European and other major trading country have signed the treaty. The important absentees are the UK, India, Hong Kong and South Africa. The CISG applies to contracts of sales of movable goods between parties whose places of business are in different states. It is very important for internationals to know which countries have ratified the CISG. Internationals situated in a country that have signed the treaty can do business more easily with other countries that have signed the treaty. The CISG will be of effect in the trade between these 2 countries. There is no more room for confusion on which rules are applicable on the trade, because that will always be the CISG, unless stated otherwise in the contract between these 2 companies. When a country has not signed the treaty, the companies have to come to an agreement which rules apply to their trade by themselves, which takes time and costs money.
In the following content, there are several examples which coming from the case law. Those examples are selected in different parts in the case law, and those will be explained how the legal problems are solved. The first topic is related to Article 31, delivery of the goods and handing over document. In this part, the article explains the related specific duties for the sales regarding to the delivery place. Normally, the delivery place will be assumed as the decided place in the contract or the place for the buyer according to this article. But it is also possible that the transport company are involved in some cases. The second topic is related to the Article 35, conformity of the goods and third-party claims. It introduces the certain standards type, quantity, quality, and packaging in the sales of goods. In other words, if the sales couldn't meet the standards from the article, it could be regarded as the breach of the contract in some specific cases. The last topic is related to the Article 74, damages. It is mentioned the normal method to calculate the compensation for the damage, but it will be only used when one party breaks the contract. It mentions the injury party could ask for the losses, also including the potential profit loss. But the range of the loss could be predicted or known when the contract has been signed. In total, the article could be combined with another article to solve the specific situation problem.
When companies want to sell their goods abroad, they have to comply to the rules of that specific country. Because this brings a lot of costs, think of lawyers and translators, it's a big step for small companies to sell their goods abroad. That is why the Common European Sales Law was made up. Companies and consumers will have the option to use a single European law for their cross-border contracts, which will not replace but coexist with national law. They will be able to use a single European law when purchasing digital products, including software and music downloaded from the cloud. The online environment will be simplified. Businesses will be able to target consumers in multiple European countries based on one contract and one IT platform, thus cutting back on unnecessary costs. Competition within the single market will increase, and consumers will be able to buy products from all over Europe at lower prices. The Common European Sales Law will generate growth by boosting export. At European Union level, this growth is estimated at approximately €5 billion per year. Not only will this boost the economy, the law also increases the level of consumer protection in comparison to some other existing laws within the European Union. That is because the proposal incorporates all existing European rules in the area of consumer protection, including the recently adopted Consumer Rights Directive. Contrary to most national rules, with the Common European Sales Law, consumers can decide from the beginning whether they want the trader to replace goods, repair them, reduce the price, or reimburse the price paid when it comes to faulty products. When a trader offers to sell products on the basis of the Common European Sales Law, the trader will have to provide consumers with specific information on their rights and on the consequences of using the optional rules. A study shows that consumers who obtain this information understand their right better than those who do not.
Incoterms. Incoterms consist out of two sections which contain a total of 10 structures. Each structure has a shortened three-letter name, in which the first letter has a significance in order to divide the structures. C terms require the seller to pay for shipping. D terms mean that the seller or shipper's responsibility ceases at a specified point, and they deal with who will pay pier, docking, and clearance charges. E terms mean that when the goods are ready to leave the seller's premises, his responsibility ceases. F terms, however, mean that the primary cost of shipping is not met by the seller. These two sections are divided by any mode of transport and only sea and inland waterway transport. And the structures inside these sections vary due to the spread of risks, costs, and the spread of responsibility of insurance. But why would you choose Incoterms over CISG? Even though CISG, the treaty, has been applied in over 74 contracted countries, it is old and not as updated as much as the Incoterms, which is updated in 2010. And Incoterms, which is governed by the ICC, is stated in 120 countries, which makes it available in multiple languages, more than in the CISG treaty, creating a smoother communication between companies in order to reduce miscommunications.